All right, United States v. Comey. Last Friday was a key day in the case. There were some big developments, and I want to take you through some of those. But before we get to them, I need to take you through some background here because we're going to be talking about two different issues and also three different judges concerning one defendant and a U.S. attorney, at least one U.S. attorney whose appointment has been challenged. And things are just getting a little bit complicated. So I've got a thread that breaks this down, and we're going to go through it. All right, the first thing that happened, or not the first thing, but the big news that happened last Friday, Thursday, and you may have seen this going around, was that Trump's DOJ got an order from a judge in the James Comey case telling them they had to turn over grand jury materials and some other key evidence in the case. And you may have thought, grr, that judge, what's going on there? Crooked, deep state judge, whatever. But as is so often the case with these things, when you dig in to what's actually going on, you dig into the documents, you look at the background of how we got to a point where a judge issued such an order, it all starts to make a lot more sense. And it isn't as easy to throw out accusations of crookedness or deep-stated shenanigans, whatever, against the judge or against anyone else. It just looks like regular adversarial court battles. And it also looks like the justice system working and the judicial system working the way it's supposed to. Mostly anyway. There's one thing that's kind of curious, and we'll get to that. So here's your background on what's going on. Nachmanov is the guy who is the district judge assigned to the United States v. James Comey. So he is the main judge in the case. He's the one handling, or will be handling, the trial if we get to that point, okay? But because of issues that have come in that require, by rule, but require other judges to come in and deal with these particular issues, and we'll get to what those are. Nachmanov ordered that all Rule 16 discovery had to be provided to Comey, to the defense, by October 13th. Rule 16 discovery is all of the evidence that the government has against you. Okay, Brady material is all the stuff that the government has that might be exculpatory. Okay, so Rule 16 is inculpatory evidence. Brady material is exculpatory evidence, stuff that could help you. And then Jinx material, you'll hear it called, it's Jinx and something else. The other name for it is escaping me. Those are the government's communications about the case, which might expose something unethical going on. All right, so 85,000 pages of discovery has been turned over to Comey, but that's not all the discovery that should have been turned over by October 13th. Some of the material that they should have turned over by now, but haven't, is attorney-client privileged, or is potentially attorney-client privileged material. That material comes from person 3 in the indictment, Daniel Richman, and it's on iPhones, iPad, iCloud backup, those things, a computer hard drive as well. And it comes from the Arctic Haze investigation. You may have heard of that investigation. We got a bunch of D-class on it, some, I don't know, dozens of pages. I want to say it totaled, with Arctic Haze, I want to say it totaled like between 40 and 80 pages that was just on that investigation. But you may remember we got D-class over the summer on like 7 media leak investigations that were run between 2017 and I think the last one ended in 2021 maybe. And they all kind of connected together because they all had to do with information about investigations that the FBI was involved in leaking to the media. They were unauthorized disclosures of information or of classified material. And so the government, and before the prosecutors, as they're about to turn over, or they're going through this material they need to turn over to Comey, they realize, and they probably knew this going in, you'll find out, that they had this set of material that was potentially attorney-client privileged, that they really shouldn't be able to look at because it's protected by the attorney-client privilege that existed at the time those communications or these documents was created. And it's attorney-client privilege because for a time, right after Trump fired Comey, Comey retained Daniel Richmond, who's person 3 in the indictment, as his own personal attorney and communicated with him. And those communications were later seized pursuant to 4 search warrants that were part of Arctic Haze. So what do you do? Well, the thing procedurally to do for investigators is to bring in a filter team. A filter team is comprised of people who are outside of the investigative team. It's investigators, it's legal counsel, and they go through the privileged material or potentially privileged material. They look for what could be attorney-client privilege, and then they give the opportunity to that client to assert his attorney-client privilege. Then the prosecution at that point, if they want that material, they can take it to a judge and tell the judge, we want this material and we should get it legally. We should be able to pierce attorney-client privilege because there's something about those communications which is fraudulent or concerns a crime. You may recall this process from the Durham Council investigation. There was a significant battle to get Sussman's communications between him and I believe Baker, Fusion GPS, Robbie Mook, other people at the Clinton campaign. And Durham was successful. And they ended up bringing up 1,500 emails and other types of communications, something like that. So that's the material we're talking about here, is these communications between Comey and Richmond at a time that Richmond was an attorney to James Comey. And investigators have this material in their possession, but it's under attorney-client privilege. They're not supposed to have access to it or much more, be able to use it against Comey. The material was also reviewed years ago during the Arctic Haze investigation, and Richmond was involved in that review, but Comey was not. So Comey hasn't had the legal opportunity to assert his attorney-client privilege over it. That's coming up now. And that's the rub, is that they shouldn't be able to use this material, and they have it in their possession. And it looks like they did use it before the grand jury. Comey has never had the opportunity to assert his privilege over these communications, but it's his right to do so. On October 19th, before the defense had ever responded to the motion, remember, they were supposed to turn over all of this Rule 16 material by October 13th. So 6 days later, before the defense had even responded to the motion for a filter team, which the government filed on October 13th, same day they were supposed to have all this done, right? The same day they were supposed to have all this material turned over, they're like, oops, we have this attorney-client privilege stuff. We need a filter team. And they file a motion for it. 6 days later, they file another motion. Now, Comey hasn't responded to the motion for a filter team, and he has 2 weeks, 14 days to do so as per district rules. Prosecutors file another motion saying, we got to hurry. We need the judge, please implement this filter team. Please expedite your ruling on this matter. Next day, the defense responds to that and says, hey, we haven't even replied to the first motion, which we have 2 weeks to do so. So we have 7 more days to reply. The prosecutors haven't told us what exactly they want reviewed or what legal basis there is for the review. And we have reason to believe that members of the prosecution have already been exposed to the potentially privileged material. A huge no-no. Later on that same day, Judge Nachmanoff, remember, he's the district judge handling the case. Nachmanoff denies the prosecutor's motion to expedite, of course, because one, the defense hasn't even replied to the original motion, and they get to. Second, the defense has another 7 days to do so. So the judge isn't going to rule on it yet. He can't. Also on October 20th, defense files a motion to dismiss for unlawful appointment of Lindsay Halligan, which I've gone over in a different video. I've gone over it in a full episode, done a full reading of that filing, and I found it compelling until I read the prosecution's rebuttal of it. And then my mind completely flipped. Motions challenging a U.S. attorney, and this is where we bring in another judge. Motions challenging the appointment of a U.S. attorney must be heard by an out-of-district judge. It has to be someone else. It can't be Judge Nachmanoff. It has to be someone from outside the Eastern District of Virginia. So Senior Judge Curry from South Carolina is appointed to handle all matters related to Lindsay Halligan's appointment. He is also handling this same issue for the Letitia James case, because Letitia James has filed the same motion challenging Lindsay Halligan's appointment. October 27th, due date for the defense on their reply to the implementation of a filter protocol, and they file one. They say they don't necessarily oppose it, but they want to challenge the underlying search warrants first, and there are 4 search warrants. They give us a little bit of information about them, but not much. It's mostly redacted because it falls within the protective order in this case. There was talk at the beginning of the case that prosecutors wanted to declassify as much as possible, and haven't really seen that happen yet. I hope that is still what they aim to do. Side note, the judge has asked the prosecution and the defense to agree on some redacted versions, minimally redacted versions of basically every filing so far on the docket and future filings, so that it can be as public as possible, which I like very much. So hopefully some of these bars will get lifted soon, and we'll see this refiled, and we'll be able to read it, comprehend more of it. But additionally, the defense in their filing, they informed the court a little bit more about the privilege spill, which is somebody, one or more persons, but we know of at least one, who got a peek at the attorney-client privilege communications and should not have, and he may have tainted the grand jury process, because that same FBI agent who was exposed to those protected communications then testified as the only witness to the grand jury that day. And one of the things that points to this guy communicating some of that privileged material to the grand jury is that Daniel Richman is person 3 in the indictment. And that's who the indictment alleges Comey authorized to serve as an anonymous source in media reporting. And how did Daniel Richman's name get brought in? Who was the witness, or what's the document that got brought up to the grand jury that connected James Comey to Daniel Richman and leaks to the media? Seems most likely that it came from these protected communications, which he never should have been exposed to, one, and he definitely never should have communicated to the grand jury. Another reason to suspect that this happened, and it was a big oopsie, is that FBI agent was immediately pulled off of the investigative team. So it's kind of like he had that big mistake, and then they realized post facto and yanked him off. October 28th, Judge Curry, remember, he's the guy handling the challenges to Lindsay Halligan's appointment as U.S. Attorney for EDVA, orders the prosecution to turn over to him all documents related to Halligan's participation in the grand jury process. And this is because, remember, he's hearing arguments against her appointment. And so he wants everything having to do with how she was appointed and how she handled the grand jury process in this case, and also the Letitia James case. October 29th, Judge Nachmanoff, the main judge, then brings in a third judge to the case. He appoints Magistrate Judge Fitzpatrick to preside over all proceedings related to the implementation of the filter team and the seized material from the Arctic Haze investigation. So those are our 3 judges: Nachmanoff, Curry, and Fitzpatrick. October 30th, Fitzpatrick sets the hearing date for November 5th. He wants to hear about this issue of the filter team protocol and the potentially privileged, but it is privileged material. October 30th sets the hearing date, November 5th. And then also on October 30th, defense files a motion for disclosure of grand jury proceedings because there are numerous irregularities with it, including the possible privilege spill that we just went over. Such irregularities, or if worse occurred than irregularities, could be grounds for dismissal. So defense wants these grand jury materials. They want the transcript. They want all the documents related to it. all the comments, that all the notes, everything. Because if it turns out that prosecution knew they were presenting privileged material to the grand jury, or if this FBI agent used attorney-client protected material, communications, and to get the indictment from the grand jury that day, that's grounds for dismissal of the whole case. November 2nd, the prosecution responds to the defense's opposition to a filter team. And the prosecution argues that, hey, the search warrants were lawful, they were judicially ordered, everything was done above board, they were well predicated, all that stuff. And that the potentially privileged materials, look, they're just a small subset of evidence. It's just 5 text threads between Comey and Richmond. Now, it probably is a small subset when you know that there's 85,000 pages of discovery here. But just because it says a small subset and then it's 5 text threads, we don't know how long those go on. It could be 100 pages worth of text threads, or it could be one single page. But it doesn't really matter. It doesn't really matter how many words it is or not. What matters is that it's attorney-client privileged communications that never should have been seen by the FBI agent, never should have been communicated to a grand jury if that didn't indeed happen. And this should have been handled, this filter team should have been brought in before the indictment. This should have happened before the indictment. It should have been challenged beforehand. Comey should have been able to assert his privilege, but here we are. Remember, it was October 13th that they were supposed to turn this stuff over to Comey, saying, hey, here's all the evidence we have against you. And they didn't do that. And they didn't do that because they hadn't done this step of a filter team beforehand. The filing also gives a timeline of events associated with the search warrants, but it's redacted. Don't know why it's redacted. It seems like the kind of thing that could be unsealed and could be public knowledge. And there's a footnote down here saying, hey, this exhibit is designated as protected material because it is a search warrant, and everything that's a search warrant in this case has fallen under the protective order in the case. But we think it should be unsealed. We don't see a reason for it to still be sealed. Hopefully it won't be for long. This filing also acknowledges that an FBI agent was exposed to the material, and he was pulled from the investigative team, and the material was separated from other evidence pending a review by a filter team. So that's confirmation that the only witness to the grand jury is also the guy who was exposed to this material, and he was pulled from the team after testifying to the grand jury. And then the indictment they returned appears to contain references to that privileged material. I mean, not just references, it seems to be based on it, which is going to be grounds for dismissal. November 4th, Judge Curry issues another order for grand jury material because prosecutors had failed to provide him with all that he had asked for. He said, look, I need a complete transcript. You gave me some stuff, but I need a complete transcript, and I need all recordings of all the statements that were made by the indictment signer to the grand jury, and it needs to include statements made prior to and after the testimony of the witness, the FBI agent who was exposed, and during the presentation of the 3-count and the subsequent 2-count indictment. So not just the one that did return an indictment. I want the one that didn't. And I wonder, are we going to learn that he testified in the 3-count one and then they realized that he was referencing attorney-client privilege materials? They yanked him and then they went back for the 2-count, and that's why the 3-count failed? I don't know, just a thought I'm having. There's some weird stuff. It's irregularities. And guess what? What does Comey need in order to get the grand jury materials turned over to him so his defense can have a look at it to see if there's a grounds to dismiss? He needs irregularities. He needs to convince the judge there are enough irregularities to warrant that. All right, now we're getting to what happened last week, November 5th, the hearing. At that hearing, Magistrate Judge Fitzpatrick denies the prosecutor's motion for a filter team. And what he does is he orders them to provide all the Arctic Haze material that they're using, that's at issue here, and the grand jury material to the defense, plus descriptions and explanations of its handling. Remember, what was this? Where was this stuff stored? Who's had access to it? What did you use it for? Why is it in evidence? Like all that stuff. He's actually issued them several. There's like 1, 2, 3, 4, 5, 6, 7 orders in this, and then another one breaks down into 4 points. He then bars the government, or also in the order, he bars the government from reviewing any of the material seized with the 4 search warrants. And he orders the government to file all grand jury material, transcript, audio, testimony, documents, etc., under seal to his docket. Now remember, these 4 search warrants, and this is something I don't remember if it was Fitzpatrick or if it was Nachmanov, chastised the government over these because these 4 search warrants go back to 2019 and 2020. So the government has had 5 to 6 years to go to Comey, to run them through a filter team, go to Comey and say, do you want to assert privilege over this stuff? They've had all of this time, 5 to 6 years, to deal with this issue. And yet here they are, 3 weeks almost past when they were supposed to turn all the Rule 16 evidence over to Comey. And they haven't done it because they don't have their ducks in a row. So it seems. Prosecutors then file a notice saying that, look, we've turned over all the grand jury material to the defense and to the court, both Fitzpatrick and Curry, same day after the hearing's over. Then November 6th, another set of orders come from Fitzpatrick. And he says the government's ordered to file a motion to unseal the 4 Arctic Haze search warrants. They're in a different district, and they've been sealed for 5 to 6 years. And I went looking for these across on Pacer, but I haven't found them. Not really surprised about that because the hack of Pacer that was ongoing earlier this year and that got into, it looks like it was a Russian hack, or at least by a group connected to Russian cyber operations. They were able to access sealed filings, including search warrants, subpoenas, all of these things in multiple cases across multiple districts. And since that hack happened in July, I think was the main time frame of it. In August, once the notice went out to all the courts, the administration for the federal court system told judges to keep sealed filings off the docket. They might file a placeholder document so that you can see that it's there and that's the docket entry number it is. And there's like a notice that, hey, we have filed these things, but the actual sealed document is not electronically on the docket. They've gone back in time to paper filings. So it sucks. And I've seen other filings that, or other cases that were sealed, be pulled from Pacer and just a placeholder is put there, but it doesn't show any action on the case. So thanks, Russia. All right. Plus, the judge this is Judge Fitzpatrick, he wants both sides to get together to work on a version of each document that is currently or potentially under seal in the docket and determine what should be redacted, which preps them to become public. So that's a very good thing for all of us. All right. I've done other updates in this case, and if you want to check them out, they're on my YouTube, they're on my Rumble as clips. I try to do shorter updates on this case of each filing that is significant. But then in my full episodes of the Just Human podcast, I go deeper into the filings page by page, and we can sometimes, through doing that, we find a greater story or unfolding, or we find more little clues about what's going on. And you get a much better read of what's happening here. You also get a much better appraisal and more appreciation for how this all works, which ends up making accusations of deep state judge doing something crooked or whatever just seems silly, because you start to understand the process for how this works and what each side has to do in order to get the judge to rule a certain way. Now, right after, I want to make one more comment on that. So this is something that's kind of lost, I think, on a lot of people, or it's at least lost in media coverage, whether it's media coverage on the left or the right or whoever the influencer is particular to. We all have our own biases, including me. But something that's lost in media coverage of any court case is that no matter what the judge does, no matter what the judge decides, one or both sides are unhappy. Every time. Every time. Every decision the judge makes, either one or both sides is unhappy. And then what happens? Either one or both sides go to the media and complain about it. And so unless you're following the docket and reading the actual documents there, you're always going to get a narrative and a portrayal of the case that comes from a media source that is being swayed by a perspective that is from one or both sides. And since those media interviews are with people who have interest in the case, either the defendant or the prosecutors who are advocating for, or the defense counsel, they're all advocating for their own position, right? It's their job to. It's the prosecutor's job to advocate and to present a perspective that is slanted towards the case they're trying to present and the side of the battle that they're on. Same thing for defense counsel. Every interaction they have with media is going to be slanted towards their defendant against the prosecution every time. And so no matter what a judge does, one or both sides is going to be unhappy. And no matter what happens in a case, one or both sides are going to go to the media and present a characterization of the events that happened that day or that week or throughout the case that favors their side and their story that they want to tell. And the only way you can see through all that and get a better perspective, a more informative or a more informed perspective on what's happening in the case, is to track it filing by filing, hearing by hearing, follow it on the docket. And that's what I try and do. Now, right after I finished the thread, DOJ filed an appeal of Judge Fitzpatrick's order. They said, look, we're appealing the order requiring the government to produce all grand jury materials to Comey because the judge can't order that. That exceeds the scope of his delegated authority, and it prematurely resolves a motion still pending before this court and was entered without the necessary findings required by law. That's fair, because the magistrate judge was delegated the authority to deal with the filter protocol and the issues related to that. And there's already a motion on the docket that Comey filed, which was in this thread, his motion for disclosure of grand jury materials, which hasn't been decided. And this judge is jumping ahead and going ahead and deciding something that both sides haven't gone back and forth enough on yet. And then the necessary findings haven't been produced. And those findings are that what it's called is there's a specific phrase from the case law. It's particularized and factually based reasons for the disclosure to happen. Well, that was November 6th. So Judge Nachmanoff, remember him? He's the primary judge in this case. And he's the one who brought in Magistrate Judge Fitzpatrick and said, hey, you're going to handle the Arctic Haze and the filter protocol stuff. He says, look, the order regarding the disclosure of grand jury materials does fall within matters referred to the court. because Fitzpatrick was designated to preside over all proceedings related to the review of privileged materials in this case. And this court, Nachmanoff, finds that Judge Fitzpatrick's ruling falls within the ambit of this referral. Indeed, the topic of potential privilege spill was raised by the defendant in both his opposition to the government's motion to expedite and the ruling on the filter protocol. So this particular issue of the spill of this protected information has been in the filings the entire time before I appointed Fitzpatrick. So I'm giving him that issue, and that issue concerns what happened before the grand jury. Subsequently, during Judge Fitzpatrick's hearing on the protocol motion, the filter protocol motion, defendants raised substantial questions regarding whether this material was shown to the grand jury. As a result, Judge Fitzpatrick properly addressed the need for disclosure of the grand jury transcript. So here's the order. Order that the matter of disclosure of grand jury transcripts to the defendant is remanded to Judge Fitzpatrick for further proceedings to analyze whether there are particularized and factually based grounds for the disclosure. So he denied the government's motion, but he didn't say obey it. You know, like, go ahead and I'm remanding it to Fitzpatrick. This is his wheelhouse. This is under his authority, and he is going to, I want another hearing on it. Actually, it says further proceedings. Fitzpatrick comes in and says, all right, I'm ordering a telephonic hearing on the issue to be held November 10th, which is today at 4 p.m. So we'll see what happens from that. It could be by the end of the day where we started this thread, which is Trump's DOJ gets new order from judge and James Comey case, which really tells you nothing. That headline doesn't tell you much at all, does it? Everything I just told you in that this thread is so much more than what that headline tells you. That headline makes it just sound like DOJ lost, Trump DOJ loses to judge and James Comey case, and then each side makes up it whatever fodder they want to make of it, right? What it really means is that the grand jury material and the Arthur Haze materials, which are the discovery James Comey was supposed to get on October 13th, and DOJ didn't get their ducks in a row, and it's not ready to be disclosed, and there's this battle happening over it, and then it turns out there's this privilege spill, and it turns out the grand jury may have been tainted by it. There's this potential huge mess. That headline doesn't tell you any of that, does it? And neither do so many other headlines or various posts about what's going on here. So now you know what's going on. And now you know that it's not some deep state judge and it's not crooked anything. It's, if anything, it sounds like there might have been a big oopsie with the grand jury. And that's what Comey's after. Now, it also could turn out that the disclosure of grand jury materials happens. The transcript, all of that, turns over to Comey. He reviews it. And let's say they even find something, they file a motion, another motion to dismiss. It'd be like their fourth one, I think, or fifth. And let's say they file it, judge isn't convinced by it. Says, nah. The grand jury could have arrived at he didn't actually communicate that. That same information that was communicated by the witness is also found in other materials that aren't privileged. That could happen too. I could say, look, the grand jury also heard media reporting on the subject that said the same thing. So that information may have not only come from that FBI agent's exposure to the privileged communications. And DOJ shouldn't have used that guy as the only witness. He shouldn't have been exposed to that material. DOJ should have engaged in this filter process before bringing the indictment. All those things, but it's not grounds for dismiss or to dismiss the case. That may very well happen. But if everything's on the up and up with the grand jury, then the case won't be dismissed. If the grand jury is tainted by evidence that the agent never should have had, and certainly never should have presented to them, then the case may be dismissed on those grounds. So today could be another important day. I expect the judge is going to decide, based on the irregularities I mentioned earlier and concern for the privilege spill, that he's going to grant the motion. And really, if we were in Comey's shoes, we would want that. And us as observers of this case, I think we should want that too, because we should want whatever indictment is brought out of a grand jury, whether it's against James Comey or anyone else. You should want everything to having to do with that grand jury process to be on the up and up and to be done correctly, so that the indictment stands, and then that person has not only was the grand jury process fair and just, you want that, and then you also want the trial to be fair and just, right? That's what you would want for yourself. And so I think that's what we should want in this case. See you on the next one.